Hello, good afternoon, and welcome to The Law. This is your legal light, it is your health law. And here we take you through our legal clinic, providing you some of the diagnosis that you require and also the prognosis that you require, so you can help yourself as far as matters of the law are concerned. This afternoon, we are continuing our discussion we have had a couple of times on medical negligence or medical malpractice. There have been news and stories about people encountering these circumstances, and in recent times, our courts appear to be delivering judgments in favor of victims of medical negligence. There have been quite a number of such judgments within a short space of time. Our guest this afternoon has just completed one of such cases. We will get deeper into that and assist you on how to identify and preserve the evidence for the purposes of prosecuting a case in medical negligence. We'll be right back. Welcome back. He just made a 4.3 million win for a poor mother for her boy suffering cerebral palsy due to medical negligence. So how do you preserve the evidence for a successful prosecution in such situations? Our guest is Albert Gyamfi. He's a law teacher. He practices the law. He's also an author of legal text. And today, by the time we're done, I'll introduce you to his latest book, Legal Text. Albert, thank you so very much for joining us.
Thank you.
Today, we are lucky to have you in the studio. We always have you via Zoom, joining us from Kumasi.
Yeah, I'm glad to be in the studio with you.
Good. And our audiences have been particularly happy because of the way you are able to break down the difficult legal things and legal terminology so they can appreciate the law in the most basic form. So thank you once again.
Oh, you're welcome.
Right. Now, when we say medical negligence or medical malpractice, what are we talking about?
All right, so just like the name connotes, it's negligence in medicine. Or should I say when a healthcare professional or an organization fails to provide the appropriate care or the appropriate standard of care resulting in injury or harm to a patient. In our part of the world, it's not that developed, but in other countries where the least case of medical negligence are going to be sued, it is mandatory for every medical facility or for every medical doctor to get what is called medical malpractice insurance. So every doctor is required to insure himself so that in the event of medical malpractice, there's readily funds to pay for the losses that would ensue. So basically, that's what I can say about medical negligence, negligence by a medical professional or a healthcare provider.
So negligence in law, even by the word, the plain English language, will mean that you're supposed to do something and you have neglected to do it.
I would not go with the plain English translation. Otherwise, it will appear that nothing was done at all. But negligence means failure to take proper care. So the act could have been done, but it was not done within the proper manner. So once we are relating this to medicine, every doctor or every healthcare provider knows that if he doesn't take proper care, he's much more likely to injure or cause harm to his patient. So whenever you are directing your actions towards the patient, you should know that if I do not take care, I'm going to cause harm. A lot of students watching me will know that this is known as a foreseeability test. And that places what is called a duty of care on you to exercise reasonable care in that particular form of treatment. So it's not always about neglect to do. Sometimes the act may be done, but it may be done improperly.
Okay. So the medical facility or the medical professional has a duty of care towards the patient who has come to their facility. And that duty of care, they have either failed or deviated in the standard in providing it.
Yes.
So we say a malpractice has occurred or negligence has occurred.
Exactly the point. So there is always a minimum standard that every person directing his action, they are supposed to apply. In some countries, the standard is higher than others. Of course, when you go to government hospitals called Ibu Konfanoche, and you have a mosquito bite, this might not be a case for you to sue for negligence if, let's say, you suffer malaria as a result. Probably in England or in the US, that would be a case of malpractice or negligence. So the standard is a bit relative, depending on where you are. And the court sets the standard based on the existing socioeconomic conditions of the place. So the standard of care in Ghana may not be the same standard of care in the US, but there is a minimum acceptable standard that every health professional must comply with. And when it falls, your action falls below that standard, that is why we term in law that you have been negligent.
So that if someone had to had surgery performed on them, there is the minimum standard across the globe.
Exactly.
As far as you are a professional, that you are supposed to follow.
Exactly.
If you deviate from it or you fail from following it or performing it at all, when in fact you have a duty, that duty of care towards that patient, then we say medical malpractice or negligence has occurred.
Has occurred, exactly.
Right. So, as I understand it, it could be a question of misdiagnosis, failure to diagnose a condition, or incorrect diagnosis. It could be, as I mentioned earlier, surgical error, mistake during surgery, such as operating on the wrong body parts. It could be medication errors, prescribing or administering incorrect medication, or the dosage for same. It could be birth injuries, harm to a mother or child during childbirth, failure to treat, not providing necessary treatment or delaying the treatment, inadequate monitoring, failing to properly monitor a patient's conditions, communication errors, poor communication between the healthcare providers or with the patient. And if I may add one, lack of informed consent, not fully informing patients of treatment risk and alternatives. After I have gone through this list, help us break it down.
All right, so I think virtually you have said it all. Medical negligence, like I said, there's a standard you're supposed to adhere to. Doctors are humans. The law understands doctors can make a mistake, but the law expects you to at least follow a minimum standard. So in medicine, there are medical practices, standard medical practices, standard medical protocols you're supposed to follow in every treatment. So when it falls below that, you have said you have been negligent. There's something I would also want to add. The fact that a doctor has fallen below the standard does not necessarily mean that he's liable in negligence. There's a difference between being negligent and being liable in negligence. A doctor is only liable for his negligence if his negligence has led to the injury complained about. So in law, we say that there should be some form of causation. The injury must be caused by the doctor's negligence. And that is where the trick comes in. It is very difficult to prove that even though the doctor has been negligent, his negligence caused your injury. And I'm sure in the course of discussions, we'll come to that and see how best that will be. But I think virtually you've mentioned that medical error, overdosing, wrong medication, surgery errors, anesthetic errors. Sometimes in surgeries, medical equipment may be left mistakenly. No one is saying that medical negligence is intentional. If it's intentional, that would be manslaughter or to be murder. But this one, we're talking about the fact that you failed to exercise proper care. We also have...
I've actually seen one such situation before.
The equipment?
Where they did what they had to do and forgot and left stuff in the stomach and went ahead and sewed it back.
Exactly. So in that case, what is the standard medical practice? You went into the theater room with some instruments. I mean, you are supposed to check the instruments before finally sealing the person up. So if you fail to do, that's what we talked about, that you are falling below the minimum standard, so you are negligent. Right. The other one, which is also very common, is failure to recognize and respond to complications and emergencies. Someone comes to you, the person needs urgent care. The person has to be referred to the bigger hospitals for treatment, but you pretend as if you can try. So when it gets to the last stage, that is when the person is referred, he suffers an injury as a result. That is negligence. The other one is premature discharge or improper discharge. So the patient is not to be discharged, but he's discharged, and some fail to give the necessary instructions upon discharge. Come to us after 2 weeks, come to us after 1 week, take this medication, do that. If the person suffers injury because that instruction was also not given, that may also amount to negligence.
And that's even where you bring in the prescription. You are making a wrong prescription, or even the dosage the person is supposed to take the drug. You give a dosage. You spoke about overdose.
Yes.
Right.
Yes. So wrong dosages, overdose dosages are all issues that will amount to negligence.
Right. You mentioned something that to be able to establish that the medical professional or the medical facility is liable, or as it were, my audience would like me to say, is guilty, then you need to do something. You spoke about causation.
Yes.
What is that, and how do you do that?
All right. So to successfully obtain a remedy or to get compensation for medical negligence, there are 4 things you are supposed to show to the court.
4 things.
4. The first one is referred to as, we've already mentioned, the duty of care. In patient-client relationship is already seen by law that a doctor always owes a duty of care to the patient. So that is not too difficult to prove. The next one is
So not only the doctor, right?
Not only the doctor, the nurses, the midwives, all health professionals owe their patients a duty of care. Both we say in law, both in tort and in contract. Contract in the sense that medical services are not for free. The person is paying. So the least they can do is to exercise due care.
Even if it is national insurance?
It's paid. National insurance is not for free. I mean, they're supposed to contribute to it. So there's a duty in contract. The second one has to do with the standard of care. Now, if you fall below the standard of care, like I've already explained, we say that you are negligent. The third one, which is sometimes the most difficult for legal practitioners, is to show a link between the negligent act and the injury that you suffered. So the doctor has been negligent, all right. He gave you an overdose of the drug, that's negligence. But that overdose cannot lead to the condition you are suffering. The doctor is not liable in negligence. So you're supposed to show that the negligent act was what led to my present situation. And that is the most difficult. We'll explain more on that. The last one is that you're supposed to show that you have suffered damage as a result. So if a doctor is negligent, but you've not suffered any damage to you, you cannot also file an action.
All right.
So all these 4 must be proved. That is why negligence is one of the most difficult things to prove in law.
Because you, the victim, and your lawyer, you are no experts, medical experts. So how do you go about proving that this headache I am suffering is as a result of the misprescription that the pharmacist or the medical professional gave me?
All right, so I think the first thing that you have to notice is that we all have to be conscious of our bodies. We all know our systems. So you were sick, you had, let's say, fever, or let's say even a stomach ache. You went to the hospital for treatment. You were given a drug. Whenever you take that drug, after some minutes, you suffer a headache. Consistently, that should give you a clue that this is, and I wouldn't take it out that some drugs would have side effects. We'll come to that. Medical professionals are supposed to inform their clients about the side effects of certain drugs. If you take this drug, you're going to be drowsy. If you take this drug, you're likely to have headache. You're likely going to have some feverishness, so that the patient is aware. If you don't do that and he suffers as a result, let's say he's going to become drowsy. You take the drug, he drives, and actually suffers road accident as a result. He can sue for professional negligence because you're supposed to give that sort of information.
So in that case, you are doing the proper linkage, which you are talking about.
Exactly.
The causation.
Yes.
That I've been given a drug. The drug makes me drowsy.
Yes.
But I was not informed. So because I was not informed as a patient, I took the drug, went behind my steering wheel, drove, and in the process, I became drowsy and got into an accident. We can trace it.
So in that case, the linkage is that the injury I have suffered is that I've suffered bodily harm.
Right.
The bodily harm was as a result, we are tracing the link.
That's
it's
right.
as a result of the accident. The accident was because I was drowsy.
Okay.
I was drowsy because I was given a medical drug. The drug was, I was not given any information by the doctor that it was going to cause it. So there's some sort of a chain
That's right.
between the act of the doctor and the harm that you have suffered. If the chain is broken at any point in time, you're not going to get any remedy. That's how it works.
That's another interesting point. You're still here on The Law. It's your legal light. It is your health law. And our guest is Albert Jenfi. Albert is a teacher of the law. He practices the law and he's also an author of legal texts. He just finished conducting a case in medical negligence successfully, and we will be getting into some detail of that particular case. But here you are. And as we were scrolling on your screens, you saw the information that we sought to give you. It could take the form of misdiagnosis, surgical errors, medication errors, birth injuries, failure to treat, inadequate monitoring, communication errors. He just mentioned that lack of informed consent, among other things. So you just mentioned that there can be a break in the causation.
Yes.
How does that happen? We have traced the thing to the lack of information to me about what the drug potentially can do to me. So what would be the issue about breaking causation for which the professional will not be held liable for medical negligence?
All right, so when it comes to causation, in law, we have something we call the But-for test. So the simple understanding I will give to our audience is this condition would not have happened but for the medical negligence. In other words, if it would have happened anyway, negligence or no negligence, then the doctor is not responsible for it, even if he was negligent. Second thing is that if there are multiple factors that could lead to it, then the doctor could be said not to have been negligent because the act could have been caused by 6 factors. The doctor's factor is one of those factors. It means take the doctor out, the other things could have still affected you. And if it turns out that all the 6 are present, then the doctor will be exonerated. But when it comes to multiple factors, the court looks at what is called the risk of substantially increasing. So if we have 5 factors, but one of them substantially increases the risk of me having the harm, and that one is what was caused by the doctor, then the court can hold the doctor responsible for negligence. But where the doctor can establish a number of factors, sometimes they can even say that this can even happen without negligence. A good example would be autism. So your child is given, you give birth to a child, the child turns out to be autistic. Let's say that there was some medical negligence along the way. But medical evidence shows that a child can be born with autism without negligence. So without even the doctor exercising that, it could be genetic. Your daughter or your son has autism. That could not be a cause of action for medical negligence. So like I said, it is always about...
But you lawyers say you take your victim as you find them.
Exactly, but if you take your victim as you find him, that means, we're talking about what is called the eggshell rule. What it means is that the victim has a predisposition to suffer an injury or harm, and I caused that injury to occur. I will not have a defense for me to say that, oh, he was already susceptible to it. So in that case, there's still causation. I caused it,
right.
But my cause is very limited. Let me bring it down for our audience to understand. Let's say that someone has sickle cell. The person is weak and fragile. I mean, normal push on you, Samson, will not cause an injury as compared to that person.
Right.
So I push him, he falls down, and let's say he suffers, he dies as a result. It will not be a defense for me to say that, oh, it was because he had sickle cell, that is why he died. There's still a causation. He died because you pushed him. So once there's the causation, whether the person is already down, it's immaterial. But if there's no causation, that is where the difficulty arises. So they are supposed to trace the link
Oh.
And that is what is very difficult. I think when I'm sharing my experience on the case that I did, how I was able to link the causation.
We'll get that. We'll get to that right away. And so let's say someone already suffers epileptic fits, and the person is about around me, and somehow I shove the person, and they begin to manifest and get into a seizure.
Yes.
Even though the person is epileptic, it is my shoving at that time that has caused him to manifest. It will be said that I have caused that. And that leads him to injure himself.
So now you trace the link. The person injured himself. He injured himself because he had epileptic fit. The epileptic fit, it was as a result of you shoving him. There's a link, you're liable. So far as the link can be
It doesn't matter that this person is already predisposed to that situation, and he could have had the seizure anytime and falling anyhow and cause harm to himself.
So the question is, if you had not pushed him at that material point, would he have had the seizure? The answer is no. You're liable. That's why. That's
maybe at that material time, he was just about to fall and start.
So that is where he says, I was not falling. You pushed me, so I had a seizure. Another one would be the frightness. Some people want to just scare people behind their back. So some people are not disposed to that. So you do that, the person gets scared. He turns around to run away. He hits his head. He falls. He dies. Who dies because they fell down? It doesn't matter. Because of what you did, that was what caused it. So once there's that causation, once you cause the act leading to the result, you are liable for it, and the person's disposition is immaterial.
Right. You're still here on The Law. This is your legal light. It is your health law. And this is our legal clinic where we try to teach you some law to empower you in your daily life. We're talking about prosecuting medical negligence. And our guest is Albert Gyamfi. And so let's talk about this matter that you have just come out of doing, and doing it in such a marvelous way. The Kumasi High Court, presided over by His Lordship George Krofa, delivered a judgment on the 15th of December 2023, and in which judgments he awarded, in favor of your client, and awarded general damages of 4.3 million Ghana cedis against the Juabeng Govt Hospital, Ghana Health Service, and the Attorney General for medical negligence. Tell us about this, and we will use this to try to give education on how to mobilize and preserve the evidence for the purposes of prosecuting a medical negligence case, because we know that that is normally the biggest difficulty.
All right, so to correct that, the court awarded general damages of 4 million Ghana cedis.
Right.
Costs of
300,000
Ghana cedis.
That makes it 4.3 million. Right.
So my client, Mabel Mensah, went to the hospital. She was pregnant. She went for a last antenatal care, and the doctor realized that she was posting. So she was 42 weeks, 3 days pregnant. Normal gestation period is supposed to be for 40 weeks. So she was above the normal gestation period. So the doctor indicated that because of that situation, she was supposed to have given birth long ago. So if you're not giving birth now, then that means that there's something wrong. Now, usually there are two procedures the doctor can undertake, either to induce the pregnancy or to opt for cesarean section. But in this case, the doctor opted to induce her to give birth. Now, when you have to induce, in Ghana, the drug you use is cytotic. Sorry, I don't know whether I can mention that on live TV.
Yes, that's all right.
But it's a cytotic. And the doctor who testified in our case, who was an OBY specialist, indicated that it was a very unpredictable drug. In other words, when you take it, no doctor can predict what will happen to you. But some of the common symptoms or the common side effects are what is called uterine rupture or fetal distress. To break uterine rupture down, so the womb can suffer a tear. So when it suffers a tear in that form, the child can be suffocating, which in medicine they refer to as asphyxia. So once that happens, then as soon as they detect it, they have to now go for plan B, which is the cesarean section. So once it's detected early, the child can be saved. In Mabel's case, what happened was that they were supposed to administer the drug And one of the early symptoms of uterine rupture is abnormal fetal heart rate. The mothers watching us, when you are pregnant, they usually put something on your abdomen to listen to the heartbeat. That's what is called the fetal heart rate. The fetal heart rate will tell whether the child is in distress or not. It also informs the doctor whether to administer the next dosage of cytotec. So for every dosage, which is a 4-hour cycle, you administer what is called 50 micrograms of cytotec. And if after 4 hours it fails, you administer the next one for about 6 times. If it doesn't work at all, then that means the mother cannot be induced. The other option is to go for cesarean section. In her case, the induction started at 4 p.m. And to explain, I'll not mention the drug again, but to explain, it is a whitish tablet. It looks less like paracetamol. In our hospitals, each tablet contains 200 micrograms. So if you're going to use it on a mother, you break it into 4 and use a quarter per cycle. So my client was made to buy the drug itself. She bought 2 tablets that will contain 400 micrograms. So at 4 a.m., the doctor administered the first dosage, that's a quarter of a tablet. At 8 a.m., he administered the other dosage, which is another quarter. So what is left now is 1.5. Now, during the first dosage, fetal heart rate was not checked. So nobody knew what was wrong with the mother at the time they administered the first one. In the second dosage too, the doctor checked it. But after that, nothing was checked. So once we administer, you're supposed to check fetal heart rate every 30 minutes because, like I said, anything can happen at any point in time. So 4 a.m. to 8 p.m., nothing was checked. 8 p.m., they checked before administering, nothing was checked. The next one was supposed to be at 12. I've already explained it's a 4-hour cycle.
That's right.
But I think the doctor failed to administer. But at 8 a.m., the doctor gave her the remainder of the drug, which is 1.5 tablets. Keep this drug. I'll come back and administer. 12 p.m., doctor does not show up. There's a change in the nurse's shift. The next midwives come in. They check her folder, and they realize that she was supposed to take the next drug, which is overdose. So she goes to her and says, give me the drug. I have to administer. And she tells the nurse that the doctor gave me clear instructions that he will come back. He says, your time is overdue, so give it to me. Remember, I said it's a quarter of a tablet.
That's right.
But this midwife inserted a whole tablet vaginally and gave the other one under her tongue. The mothers say know what I'm talking about. They placed it under her tongue for it to melt, and she swallowed. So she was given 6 times the regular dosage at that particular point in time. And after she took the drug, she started sweating, according to my client. She went to the bathroom, she squatted, and she realized that she was bleeding profusely. So out of pain, she called to the nurses, and according to her, let me use the same words, she says that the nurse told her that she was exaggerating the labor pains, because this is a second pregnancy. So you have been through one previous pregnancy. It appears you have never been pregnant before. So they claim she was exaggerating the labor pains. So while she was lying down in a pool of blood, remember this one was at 1:20 p.m., the third dosage that was administered. Around 2:50 thereabout, another nurse came, found her, and when she saw the blood, she called in the doctor. When the doctor came and examined her, it turned out that she had had that uterine rupture. So it could happen that when she was given the overdose, she suffered a uterine rupture, but she was not attended to until 2:50 p.m. Now, for those who do not understand uterine rupture, the womb has a diameter of 8 centimeters, longitudinal diameter of 8 centimeters, and latitudinal diameter of 5 centimeters. So if you have a rupture, the baby will come out of the womb and will be lying in the blood. According to the medical expert who tested, so that's how he explained it.
Okay.
Will be lying in the pool of blood. So just like you have your head underwater. So the child was suffocating all this while.
Right.
And once the child is suffocating, there is a block of flow of oxygen to the child's brain. So portions of the brain will be dead, and while the portions die, that is what leads to the cerebral palsy. So that is how the link comes up. The child suffered cerebral palsy. Cerebral palsy is as a result of asphyxiation, or the difficulty in breathing. The difficulty in breathing was caused by the uterine rupture. The uterine rupture was caused by an overdose of cytotec. The overdose was as a result of negligence, so then the hospital was found liable for it. So that is how you trace the root, and that was how my client was successful in this case.
And yes, because you were able to prove that this medical condition suffered by the child is as a result of these things that happened that shouldn't have happened. So, interesting. I'm looking at a few things, and lawyers go through this. You are not a medical doctor.
Yes.
But because of this case, even see the way you are making the presentation shows that you've had to study to understand this particular medical circumstance.
Yes.
So how do you go about proving to a court that this is actually what happened when the medical information details will be with the hospital?
All right, so first, you are supposed to procure the evidence, which is the medical folder,
right,
and critically examine. I'm using the word critically because, like you explained, you are not a medical person. I cross-examined a doctor who had 18 years experience in medicine. 12 years was as a specialist in OBGYN. So you, the lawyer, you're supposed to know the file and be able to explain it. Now, the difficulty, like I explained earlier, is getting the file. Now, most doctors or most hospitals are not willing to give you the file once you apply. And it becomes much more serious when they know you're using it for purposes of litigation. But as a form of education, it is your right as a patient to get a file. So you can walk to the hospital at any time and demand for a copy of your file. And they may not give you the original. They can make a photocopy out of it, and then you pay the cost and get it. So no hospital can deny you of your file. Right. The fear of most legal practitioners is that there may be alterations by the time you get. How do you get a genuine file? For my case, what I did was, while the matter had settled, we filed the case, I think, after the child was about 2 years old. So after 2 years, the controversy surrounding the case would have settled. Now, for medical malpractice, it's a tort. So you have, by law, you have up to 3 years.
3 years. File.
So 2 years, go to the hospital. The issues would have been forgotten. You act for the file, they're going to give you. Now, most hospitals also do the computerized system. So once the doctor keys it in and signs out, it will be difficult for the same doctor to correct it. That's what I was told. I don't know if that is possible.
All right.
But the same doctor cannot correct it. It goes to a database, and you can only get it from that database. If you try every means to get it and the hospital is not giving it to you, then you have to go for a court order to compel them to give you the file.
Could you also resort to the Right to Information Act, which actually allows you to seek such information, and it says such information ought to be given to you even at no cost also?
Yeah, I think you can, but I mean, I think the Right to Information Act will be a long route.
All right.
Because you have to first make an application. If it fails, you have to apply to the Right to Information. I mean, to me, it's a long route. Apply for mandamus, what lawyers call, because it's a public duty. It's my right to get it. So I apply to the court for just an application, file a mandamus for the court to compel the medical to supply. If they don't cite everybody in the hospital for contempt. They're going to give it to you.
All right.
So I think the right it's another route, but to me, I think it's the longer way of getting it.
Okay.
Once you get it, it will be difficult to get a doctor to come and testify on the
That's the next question I was going to, because you are not a doctor, you are not a medical professional. So how are you able to prove to the court that this is what exactly happened? How are you able to do the interpretation of the circumstances as you have done? The medicine that was supposed to be given, the period that it was supposed to be given, and the lapse in time, and the overdose at a certain time. How are you able to interpret all of this to a court to tell them that this is what led to this child who is now suffering cerebral palsy? All
right, so first, medical negligence cases are not for, excuse me, say a lazy lawyer. If you do not have time to study your brief, you don't have that sort of dedication, prosecuting a medical negligence case will be very difficult, because medicine is 7 years of education. You cannot pretend to know it because of just one case. But for me, what I did was I consulted 9 doctors on this case. And out of the 9 doctors, 3 were OBGYN specialists. I wish I could mention their names and show that gratitude, but to avoid victimization, I have to
that's understood.
Keep that. And also, in a firm, you work as a team. I would want to appreciate my colleague who is no longer with us, Hilda Mansour. She's watching here. She did a great job on that case with me. She went around. I'll go to this doctor, and she has to also go to
the Hilda I know.
The Hilda you know, yes. So what happened is, after going to so many doctors, you build a case theory. This is my case. Now, with that case theory and copies of the medical folder, give it to other doctors to review. And most doctors think that, even if they had done right, these things could still have resulted. Sometimes they will discourage you because they know you're going to see their fellow doctor. What you want is there a possibility that this could have happened? Because in civil litigation, you have to prove only on the balance of probabilities.
That's right.
Is it probable that if they had exercised good care, the child would have been saved? And most of the time, they'll tell you that yes. If they had exercised some due care, the child would have been saved. So you go to them and get their advice. The next thing is the medical expert that the defense will call. So most of the time, the state has so many doctors at their resources. And in tort, there's this case of Bolam. Bolam establishes that once you are able to get a medical person who will come to the stand and say that, oh, what he did was fine. If I was in that medical situation, I would have done the same. That case has been overruled, all right? But most people have still that mentality. Yeah. So as soon as it happens, they'll call an expert who will come and say that.
Dr. Enes Dapa took us through Bolam here on this show on medical practice, malpractice. You know, he wrote a book. He's written a book about medical malpractice. Yes, that's right.
He's my lecturer. Now a quarter of a page, a very good
That's right, yeah.
So once the medical doctor comes, that is your chance to put your case across. And you solicit or get him to admit that what you're saying is true. And the good part of it is that it is documentary. This is a document.
So you need a medical professional who agrees with your position.
Yes.
Then you call them to come and testify against.
That's what I'm saying. You will not get anyone in Ghana. And because most of these cases, you do pro bono, the finances are not there.
That's right.
Outsourcing a medical doctor outside Ghana will also be difficult. The person will give you the information, but come to court and testify, he would not come because against his colleague medical doctor. So what you do is that information that you have, that lapses that you have been drawn to by that doctor, put it to the doctor.
That you'll be cross-examining the one who caused the problem.
Exactly. And because it's documentary, you agree with me that you are supposed to have conducted the fetal heart rate before the induction process, yes. And supposed to be conducted per medical practice every 30 minutes, yes. This is a medical folder. Show me where it was done.
All right.
He will have no other option than to say that from what I have inspected, it's not there. And they have what is called the drug administration chart. The drug administration chart shows the drug that has been given to the patient. Drug administration chart shows that you administer the drug over the dosage. There's nothing the medical person can say. But because you cannot call a doctor to confirm that the right dosage is this and that what was given was an overdose, always use the medical expert that the other side, which is the defendants, are also going to call. The last one, which I also want to talk about, is the address. Now, in this particular case, I wrote about a 30-page address. Now, for my addresses, I use font size 12, single spacing. I wrote 30 pages.
Single space?
Single space in 30 pages. And my reason is that just as the lawyer do not understand the medical terms and the medical procedure, the judge who also attended law school does not understand.
Okay.
And in this particular case, we conducted the case, we finished with the case in about...
So the address he's talking about is what some of you have become aware of and you know as the...
submission.
Legal argument, so to speak. Yes, so when the case is over, everybody has testified, the evidences have all been received by the court, and the trial is over. The judge would now say the lawyers, both for the plaintiff and for the defendant, they should now bring their arguments, so final arguments. They'll look at the testimonies that were given in the courtroom, they'll punch holes in them, they'll use some of them to support their case, they'll pick the evidence and say, exhibit this, confirms this case, this is that. They'll write all of that, and they'll use law, statutes, even if it's the constitution, provisions. They'll use legal, as it were, case law, what maybe the Supreme Court has said in a similar case in this some years ago, or in England or in the US, when a case like this happened, this is how they rule. And they'll use that to write a full argument to convince the judge to take their side of the case. That's what he said. He wrote a 30-page, single space, 12
size for address.
Yes, right. Go ahead.
So what I'm saying is, you school yourself about the case. Do all the online research. break the case down to the barest minimum for the judge. Don't forget, it is not only your judgment that the judge is writing, he's writing others.
Right.
So he will not have time to do the research that you're expected to do. So do all the research, have the address be like lecture notes, school the judge on what the standard medical practice is, where the causation is, where the default is. From the testimony, what the expert said, that confirms the position, so that when the judge reads it, he will have a full understanding about the case. No judge will call another medical doctor for an explanation. And when he feels that you are not making sense or you are not convincing enough, he's definitely going to rule for the other side.
Right.
So you put every effort you can in your address, break it down to the barest minimum. For the
Thank you very much, Albert Jemfi here. And we will open the phone lines right now. Call us if you have any question, if you have something you want to contribute briefly. If you're a medical doctor, if you're a lawyer, and you want to contribute something briefly, do so. Now, I have read elsewhere, in such a situation, the amount of compensation will be far more than 4 million.
Yeah, in my case, I requested
because it is for the life of this child who can't do anything. And people who know cerebral palsy, the child is become unable to do practically anything. The parents need so many other things to help. The person needs care, you know, and so on. So for the person's life, that's not enough.
I mean, you will be surprised to know that the state has appealed against this case, probably because the amount that the judge awarded is to them on the higher side. But like I explained, I requested for 10 million Ghana cedis, and the judge awarded 4 million. I feel it's inadequate, but at least I did not appeal against it. But the doctor who testified stated that it's going to be a lifelong condition.
Right.
Cerebral palsy is incurable. The child will suffer limb movement, so he cannot use any of his limbs. His hand, his legs are gone. They suffer from neck problems, so they cannot keep their neck straight.
They have no coordination.
Nothing. There's nothing. They can't read, they can't swallow, they can't walk, they can't crawl. They are just lifeless. That is the condition. Now, if this child has been saved, then we have to put him in the position. That's the award of damage, as far as money can do.
Okay, so what is this child's condition now? And I want to use that to examine if, for my own satisfaction, if 4 million is enough for them.
So the child is just lying down. That's the best explanation I can give. So this child, since birth, has not been able to chew. So every food it takes is liquid. Every food this child takes is liquid.
At what age now?
He's now 6 years.
6 years?
Yes, every food it takes is liquid. That child cannot have hygiene on his own, so he still wears diapers at the age of 6. He cannot crawl, he cannot walk, he cannot talk. That means he cannot go to school. He does not have neck coordination. So you just keep him to sit down, then his neck just goes over in that manner. Yeah. So his mother, who I always have pity on, has to carry this child at her back for God knows how long. So virtual, and she tells, apart from this physical...
If you're watching us, the lines have been opened. Sorry, Clement, we'll pick you again if you call. 030-221-1694. Hold on, we'll come to you shortly. Yes.
Yes, if you pick this, take the physical condition and the spiritual side, in Ghana, everything is spiritual. And most people link that this child is in Twi, we call them in Suba, is a demonic child from somewhere else. So people will shun the mother. The mother used to be a seamstress. Now nobody is willing to engage her.
So hold that for me. Charlotte, you're calling us from Ablekuma.
Yes. Good afternoon.
Good afternoon, Charlotte.
And good afternoon, your esteemed listeners. And the good work you are doing for Mother Ghana. I want to contribute to the program.
Yes, go ahead.
I had a similar problem where I lost my sister through medical negligence from Cocoa Clinic. We went to Cocoa Clinic.
Charlotte.
That was
Charlotte.
Hello.
We will advise you not to mention the medical facility because they are not here to give any defense to themselves. So just speak about what you know to have suffered, what your claim is, briefly as you can, but don't mention any facility or anybody's name.
Well said.
Go ahead.
I took her there. She had problems with her stomach, like heartburn, and she was diagnosed of having a heart attack. Luckily, the medication they wrote for her, I went to buy it, but before they could administer it, the doctor that was on duty had closed. So the next one that came did a thorough examination and realized that it was gastritis. So they didn't administer that medication. She was treated. After 3 months, she was ill again, and we went. And she was told she was low on blood, and that she would be given transfusion, which we went to Prosecuting Govt because she herself was a donor. We got about 4 pints of blood from Prosecuting. She was given 3. The 4th one, I called the doctor that morning and he told me my sister was fine and that she would be discharged out because from the previous day they were just observing her to discharge her. That was a Wednesday. So Thursday, I left the house with the hope to close from work and go and pick my sister home, only to be called by my cousin who went to sleep earlier in the evening that my sister was in distress. In actual fact, when I got there, the nurses were not doing anything. She was in distress, she couldn't breathe. So I got annoyed and asked them, would you do something for the patient? And I realized they were still giving the transfusion and student nurses were doing. And the way they were handling the blood, and I got annoyed and told them, if something happens to my sister, I will take them home. That was where they came to put hospital on. Throughout the night, we didn't sleep. So the next day, then they decided they were referring her. In actual fact, the way my sister was, her hand became very swollen and was peeling off as if it was the hand on which they were giving the transfusion, as if it was bent, you know. So finally, they quickly did the referral to Accra Regional Hospital, Beach, without any referral note. And because I was so much in distress at that time, I didn't even press for any referral note or anything. I just want my sister to be well.
All right.
I took her to the regional hospital. She was there till Sunday afternoon, and she passed. So upon a thorough investigation and questions from the doctor, and I asked for the possibilities of how the patient has transformed from happy-go and happy-go-lucky to what led to her death. Then the doctor told me that there were 2 possible things. Either she was administered the wrong medication or she was given a bad blood or contaminated blood. And I was very sure it was contaminated blood, but because the way they were handling the blood, they removed it and pour it in a pure water rubber and said it was not good. In actual fact, it was very painful to me. That's the only sister I had in the world. And if I had to press charges, I would only be hurting myself, going to do evidence and do things. And my sister will not come back.
All right.
So I let it go. But this is what doctors are doing in Ghana and killing innocent children.
Okay.
And people.
Thank you for sharing, Charlotte Ablekuma, calling us from Ablekuma. And once again, she mentioned the medical facility's name. And as I said, the medical facility is not here present, so we are unable to confirm and to verify these claims at this moment. If you're calling us and you have a similar situation, we'll advise that you don't mention anybody's name or any facility's name. And in fact, we can just take a couple of questions. We can't take a narration of a circumstance like this anymore because our time is running out. You can still call. The numbers as you see on the screens. And before we close, I will try and share with you some footage, if possible, so you see the case of the child that we are talking about, for whom 4 million has been awarded by the court, and we are being told that even that is being appealed. Yakubu, you are calling us from Kumasi. Let's hear you quickly, Yakubu.
Yeah, that's something. Good afternoon.
Good afternoon. Go ahead with your question.
Last time I was sick, and I went to a second hospital, and the doctor gave me that I should go and make test. So the doctor had all the tests, he had my urinary site. So when he went all the tests and leave the urinary site, So when I came home, I go through the paper that the doctor gives to me. So I see to it that parents they didn't take it. I was shocked. I didn't know how. I said, so that means all what I go through, I didn't sacrifice the requirement that they have to give me those drugs that they give me. And I was surprised. How can like a full hospital do this kind of negligence? It's history. Our hospital goal is just saving us from the doctors to kill us.
Okay.
The Lord, they go to blessing. And sometimes we need cases so that we can take these things up so that they
Thank
they
you.
are corrected.
Thank you very much, Yakubu. What do you say to Charlotte Famanyami?
Yeah, that is a big problem. If I had a huge task convincing my clients that go to court. So what I told her that you would give it to God, but this child needs to survive. So go to court, get the money, give it to the child, and give yours to God. That's fine with me. But you see, the difficulty is, in Charlotte's case, my sister is dead. No amount of litigation will bring my sister back. So, Famanyami. And that is what has been perpetuating this kind of act in Ghana. I think, sue, take action. Even if you don't like the money, take it and give it to charity. Let some people feel culpable for what they have done. It will send the signals out there, and we can reshape our health system. Other than that, these things will not work. Every lawyer who has handled medical negligence has this challenge.
So Mabel's child, what's the condition now?
The condition now is that the child is lifeless. Like you mentioned, the court has awarded 4.3 million Ghana cedis. We have not received the PESWA because, like I said, there's an appeal and there's also a stay of execution. Stay of execution means...
But you need these monies...
For the child to survive. I know. But so my greatest fear...
Are there, for example, plans in situations that I've become aware in Ghana about cerebral palsy, which is as a result of medical negligence? I've seen a number of them, and you can see that these poor parents are looking, if they got something, some help, they could go elsewhere and get some help that may assist the child to improve a bit.
We have been informed that the child will get some improvement if he goes outside the country.
Okay.
We've heard of India, UK, and the US. But the problem is the finances. Nobody is available to support. If I tell you that I financed most of the parts of this case, you'll be surprised. The entry of judgment, the fees to transport the child to the court, the filing fees and all that were financed by me.
I'll not be surprised
because they have virtually not. If you are not touched, it's difficult to do medical negligence cases. But the problem is that the child has still not received any part of the money. And my greatest fear is this child might not survive before the money comes. Because day in and day out, his condition keeps dripping.
And appeals can drag.
Exactly. We even made a request, pay part of the money. This appeal, I don't have a problem. Just give us a portion. That too is also another challenge.
That's a very difficult one for you, but as the audiences have been saying, thank you very much for the work you are doing. And this has been the law. It's your legal lights. It is your health law. And Albert Jemfi is helping us to know the things to look out for to be able to determine that some medical negligence has occurred and we need to do something. You seek legal advice, you gather the medical records, documents, and experiences. You consult with a medical expert, he said so you get sufficient information. You will need a medical expert to testify for you in court, but they will not do so, and so they help you with the information. Then you or your lawyer will use it to cross-examine the person who may be in. Kweku, you are calling from Afenya. Can we hear you? Okay, Kweku. Okay, so Kweku in Afenya says 4.3 million is small. It should be 10 million. So in that case, wouldn't you be arguing before the Court of Appeal where they have now appealed that they should rather increase the amounts.
Yeah, so once they have filed the appeal, if I tell you the truth, even the notice of appeal has not even been served on us. It's attached to the motion for stay of execution. But if you have to go if you have to go before the Court of Appeal, definitely I'm going to put that argument up. It's discretionary. So once you have decided to appeal, the Court of Appeal has the opportunity to enhance. The difficulty, however, is that unlike the trial judge who had the opportunity to see the child and assess the condition of the child, the appellate court does not have that opportunity. They only look at the records. So it's difficult for them to see it from the perspective of the trial judge. If the trial judge awarded 4 million Ghana cedis, for the Court of Appeal to enhance it is possible, but I don't know.
All right, thank you very much. And you will say that our courts are being progressive in this direction because of the recent cases we are seeing.
Yes, and I think whilst congratulating the courts, we should also give some credence to the lawyers. The lawyers who are prosecuting this case are also doing well. Like I said, if you are not touched doing medical negligence, because the clients cannot pay you.
And doing it for free, so to speak.
Exactly, the clients cannot pay you.
If it ends up and there's no win, perhaps you can't get anything to pay back all the expenses that you have made.
Exactly.
All right, thank you very much. And this child, Mabel's child, has an emergency urgent need. So why can't the state assist by paying some of the money to assist these parents rather than this approach in prosecuting an appeal? I suppose they should be listening. I'm Samson Lardy. This has been The Law. It's your legal light. It is your health law. My guest has been Albert Gyamfi, who is a legal practitioner, a lecturer, and author. His current book is Principles of Commercial Law in Ghana. This is the 2nd edition. Any legal text bookshop, we'll find them.
All right, so you can get this from Legalities at the High Court Complex. You can also get it from the law school bookstore. And if you need it in commercial quantities, you can call 0240-232297, 0240-232297. And whatever copies you need, you can get.
Thank you very much.
But this is Samson's copy anyway.
Thank you. And I'm going to go through it as quickly as I can. Have a good afternoon.